Hi, this is Dan Smith. Welcome to today's episode of Legal Scrubs. Today I'm going to be talking about termination clauses in physician employment agreements. When you are negotiating with a prospective employer, whether you are a physician coming out of a residency and going into your first full-time job, or whether you are a more seasoned, experienced physician and you're looking to enter into an employment agreement with a hospital or with another group practice, one of the clauses that you need to pay particular attention to is the termination provision. In other words, what are the rights for your employer and what are your rights as the employee with respect to terminating the agreement? In essence, or in summary, in short, there are essentially two types of termination clauses in a contract for a physician or really for any contract. One is a termination for cause, one is a termination without cause or for no cause. A termination for cause provision enables a party to terminate the agreement because the other party has essentially broken the contract, breached the agreement. And typically, a termination for cause provision will set forth a number of actions or inactions or events that might occur which would give rise to that party's ability to terminate the contract for cause. For example, if you enter into a physician employment agreement with a group practice and it provides that the employer, the group practice, can terminate your physician employment agreement for cause, it may list one of the causes, loss of your medical license. That simply means that if you were to lose your medical license, the group practice could terminate your contract. That's pretty simple, pretty understandable. There may be other reasons for terminating for cause that are set forth in the agreement, such as conviction of a felony or losing your ability to participate in the Medicare program, losing your DEA certification and license, that type of thing. On the other hand, you may have a contract termination provision that is called a termination without cause or for no cause provision, which essentially means a party can terminate the agreement without any stated cause, for no reason, for any reason, it doesn't matter. And those are common, but you have to pay particular attention to it in the context of negotiating your contract. For example, if your contract provides that the other party, your employer, in our example, the group practice, can terminate your employment without cause on a 30-day notice, that means that whether you have a 1-year, 2-year, 3-year, 5-year agreement, it doesn't matter. Essentially, what you have is a 30-day agreement. Now, it's common in a termination without cause context that the time frame is a little longer than 30 days. And it may be that if you are negotiating a contract with an employer in your field, if you're a doctor who's going into a practice and you want to negotiate an employment agreement, you may want to talk about whether it even makes sense for your employer, when you turned down other offers, moved across country, relocated, bought a house, all those kind of things, that your employer can just simply terminate you for no reason. So it may be that you don't want to have an employment contract that has a termination without cause provision in it at all. Or it may be that the parties can agree on a termination without cause after a certain period of time, such as 1 or 2 years, something like that. It also is the case that even in a termination for cause provision, you may want to have the ability to cure the problem that gave rise to the termination for cause. For example, if your employer seeks to terminate you because you have failed to provide some service or some undertake some obligation that you have under the contract. For example, doing call as you were supposed to, or showing up for work as you were supposed to, or doing some other things. You may want to have the ability to cure that problem, so that if given 30 days, you will fix that problem so it doesn't exist anymore. That way, if you have a termination for cause provision, you probably will want to have the ability to cure the default, cure the defect, cure the breach, so that the contract doesn't necessarily have to end. Another thing to look at when you're looking at a termination for cause provision is in the context of how does it operate with your compensation payment methodology. If you are a physician who has some component of your compensation that's tied to productivity, for example, and you have a contract that allows your employer to terminate you, let's say without cause, on 90 days notice. During that 90-day period, you may still be employed by the group practice, but they may say, don't come to work, we don't want you here, we'll pay you, but if your compensation is tied to productivity, if they're not allowing you to be productive during that 90-day period, your compensation obviously is going to suffer. So one thing to keep in mind is if you do have a contract that has a termination without cause provision with some kind of period of time during which they have to give you notice before the termination becomes effective, say 90 days, if your compensation is tied to productivity, that tie to productivity could be a serious problem for you on the amount of compensation you would be entitled to during that notice period. So all of that to keep in mind, that you have to look at the whole contract as a whole. You have to look at it, all the provisions, how they might relate to each other. And in particular, with termination provisions, you have to make sure that you're comfortable with the language, whether it's a termination for cause, and if it has a provision for termination without cause, what the notice period is, if there's a compensation component that's tied to productivity, how that would work during the notice period. Just lots of things to keep in mind. I hope that helps. I hope that keeps you on track in reviewing your physician employment agreements. If you have any questions, please feel free to reach out to me, Dan Smith, at DPS Legal Counsel, and I would be glad to talk to you about your physician employment issue.